The webinar will begin shortly. Please remain on the line. The webinar will begin shortly. Please remain on the line. The webinar will begin shortly. Please remain on the line. The webinar will begin shortly. Please remain on the line. The webinar will begin shortly. Please remain on the line. The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon. Welcome to the next webinar in our ABI Live series, Enforceability of Intercreditor Agreements. Today's webinar is presented by the Secured Credit and Bankruptcy Young and New Member Committees. During the webinar, if you have questions for the panelists, please type them in the GoToWebinar conversation box on the right of your screen. Panelists will be able to answer questions throughout and at the end of the webinar. For those of you seeking CLE in our pre-approved states, please be sure to copy down the 3 numeric codes that will appear clearly during the presentation so that we may verify your participation when you request credit. Today's webinar is moderated by Justin Sabin. Justin is an associate in the Phoenix office of Brian Cave. His practice includes commercial financing transactions, commercial workouts, and business bankruptcies. He focuses in a variety of fields, including the emerging fields of cryptocurrency and blockchain technologies. Justin is a regular contributor to the Brian Cave Bankruptcy blog and has been included in the Southwest Super Lawyers Rising Star list since 2014. Justin, thank you for hosting us today. Now I'll turn it over to you to introduce our speakers.
All right. Thank you, Martha. Good afternoon, everyone. Thank you for joining us today for our presentation. We'd also like to thank the ABI for having us out today. In addition to myself, our panelists are Catherine Bell, who is a partner at Paul Hastings in the finance and restructuring practice, and she's in the firm's Orange County office. Catherine focuses on commercial and corporate financing transactions, representing a diverse range of lenders and borrowers in connection with working capital facilities, acquisition financing, restructured financings, and other leveraged finance transactions. She also has significant negotiating and intercreditor arrangements of all types that we'll be discussing today. She's also the co-author of the treatise Asset-Based Lending, A Practical Guide to Secured Financing. Next up, we have Sarah Borders. She's a partner at King & Spalding in the Financial Restructuring Practice Group in the firm's Atlanta office. She's also the chair of the firm's Lateral Hiring Committee. She has extensive experience representing creditors and debtors in a number of the country's largest workouts, restructurings, and bankruptcy cases. Her insolvency work spans multiple industries with a focus on issues in financing insolvent entities and real estate restructurings. She also has represented lenders and borrowers in a number of complex real estate financing transactions. And finally, we have Andrew Tao, who is a managing director on Cantor Fitzgerald's high-yield distressed trading desk in New York City. Andrew writes and speaks with clients on a variety of distressed, stressed, and high-yield investment opportunities. He's an industry generalist with a particular focus on investments driven by litigation or regulatory issues and liquidations. Before joining Cantor Fitzgerald, Andrew was a senior research analyst at a $1 billion+ hedge fund, a senior vice president at GMP Securities, and an associate in the corporate restructuring department at Skadden Arps, where he focused on Chapter 11 and insolvency work. Our agenda today will be the discussion of 3 primary topics relating to intercreditor arrangements. First, we'll have an overview of the primary intercreditor arrangements, some background information. Second, we'll go through key points of negotiation, try to get into some of the meaty issues that in the negotiation phase you want to be thinking about on intercreditor issues. And then lastly, we'll get into a little bit of the case law and some of the enforceability considerations, primarily as they relate to bankruptcy. So with that, I will turn it over to Catherine and Andrew.
Great, thank you so much, Justin. All right, so we're going to start off, with the basics. I know we've got participants on this program with a range of experience, so we're going to start with the basics and build up. The overview of primary intercreditor arrangements is going to go through 3 primary topics. First, what are the circumstances that give rise to a need for intercreditor or subordination arrangements? Second, what are the key concepts that take a central focus in intercreditor arrangements? And third, what types of documentation, what specific agreements are used typically to document these structures? So we'll start out with what circumstances raise intercreditor considerations. So this is slide 4, if we can go back a slide. If you have a circumstance involving multiple creditors plus different underlying indebtedness or other obligations, plus either common collateral or common obligors, that's the point in time where you need to be considering whether you need to have a documented intercreditor or subordination arrangement. So we'll move on and talk about the primary types of intercreditor arrangements. Andrew?
The primary types of intercreditor arrangements are lien subordination, such as a first lien or second lien intercreditor arrangement on the same collateral, or split collateral intercreditor arrangements. Most often in that circumstance, you might have a bank that has a first lien on the working capital and a second lien on the hard assets of the company. Well, the term loan or the secured notes have a first on the hard assets and a second on the working capital. And then you also can have payment subordination or debt subordination, and sometimes that appears in an intercreditor agreement, and sometimes that appears just in the context of the bond indenture for the subordinated debt.
Right, and then the third situation that you may encounter is one that involves both debt subordination and lien subordination documented in one intercreditor agreement. And a circumstance where that could arise, and what we've seen over the years become increasingly more common, is in a mezzanine situation where mezzanine debt may have historically been unsecured as to operating companies in a given group, but to improve their position, they may negotiate with a senior creditor to be not only subordinated debt, but also secured. And in that circumstance, they'd have payment subordination or debt subordination, as well as lien subordination. So you'll see a lot of concepts baked into one intercreditor arrangement. So that takes us on to what I think is one of the most important features to nail down early in the process when you're documenting intercreditor arrangements, and that is, what do you have? Do you have lien subordination, or do you have payment subordination? And I find that there's often some confusion between folks when they're drafting maybe initial term sheets, or speaking quickly about the parameters of a deal term, they may just refer to debt being subordinated. So we thought it was important to start out with, what do we mean? So let's start out with lien subordination. Lien subordination is a circumstance where one creditor agrees that its lien on the common collateral is subordinate and junior to that of another creditor on the common collateral. Payment subordination, which can also be referred to as debt subordination, is where one creditor agrees to postpone payment of all or some of the amounts that it is owed until the other creditor has been paid in full. So, and you can accomplish payment subordination either contractually, so you can have an intercreditor agreement or a subordination agreement that contains payment subordination terms, or as Andrew mentioned, it might be baked within the terms of the debt instrument itself, or you can structure the transaction so that the subordinated debt is structurally subordinate and achieve a payment subordination arrangement in that manner. And so when that occurs, you might have a group of legal entities, and the entity that is the opco may not be an obligor on the debt that is intended to be subject to payment subordination. So the only way for funds to get up to the obligor, if you have a holdco who is the obligor on the subordinated debt, is for there to be dividends or other transfers of assets from the operating entity up to a holdco shell entity. And the parameters limiting the flow of those assets are documented, either in a credit agreement or other documents to prevent the movement of those assets.
And sometimes, just to further that, the instruments at the holdco will sometimes have a pick toggle option, so that if even if funds to fund a coupon are not available, for one coupon, they can, it doesn't necessarily cause a default. It allows the company to have a little bit more runway.
Yeah, that's right. There's a lot of features like that that can complicate the arrangements.
Yeah, you can complicate almost as much as you want, and people often try to. And then, lien subordination and payment subordination, have some similarities. In lien subordination, the proceeds of enforcement actions against the common collateral are required to be paid off to pay first the first lien obligations before the second lien obligations. But the distinctions are that in lien subordination, other payments from non-collateral are required to be applied first to the first lien obligations, are not required to be applied first to the first lien obligations. So if the payment comes from another source other than common collateral, whether it's unencumbered assets or assets that are separate collateral, that payment could be retained by the second lien. Whereas if it was payment subordinate, they'd have to turn over everything that they received. And so obviously the distinction between lien subordination and payment subordination is most significant in situations when there's a material amount of assets that are not collateral.
Right, and in today's market, depending whether you're in the large cap world or the middle market, but frankly, we've seen an erosion of the collateral packages in both worlds, whether it be assets that are expensive or a little more challenging to perfect a lien on, or just assets that at the outset were not a part of the business, where they're excluded from collateral at the outset. This is something you need to think about if you have, a complicated capital structure with other parties and interests. If there's going to be a pool of assets out there that'll be unencumbered, it's important to understand what does that mean and how does that impact the various intercreditor relationships involved. Other areas where lien subordination and payment subordination intersect, one of them is, you may have heard of something called the absolute priority rule or the relative priority rule. One of my colleagues refers to the relative priority rule as the big boy rule. But what this is you always have a provision of an intercreditor providing lien subordination that states under what circumstances are the lien subordinations in place. And so absolute priority provides that any liens purported to be covered by the liens of the, by the collateral package of the first priority lender will be in a senior position regardless of whether they're valid and perfected. Relative priority refers to the concept of them only being in a priority position to the extent that they have a valid and perfected security interest. So that raises some issues. One, where you have excluded collateral. Two, where you have a circumstance where there's been a failure to continue perfection on assets securing the first priority obligations, or where you have assets that cannot be subjected to a perfected security interest. So those are interesting situations where, if the first lien lender neglects to continue their perfection, there may be a situation where a second lien lender would recover more than the first lien lender. And so the question is, what's the intended arrangement? Most market transactions are set up with an absolute priority rule because that does a better job of preserving the expectations. However, in privately negotiated transactions, it is not unusual in club-based deals, in smaller privately negotiated transactions with active second lien lenders to see this the subject of a high degree of negotiation. Because otherwise, that second lien lender could be put in a position where the first lien lender fails to perfect their lien and would not be entitled to certain distributions in a bankruptcy as a result, but the second lien lender would be required to turn over the proceeds that they receive on account of their perfected lien to have it flow through the payment waterfall that's in the intercreditor. And that's an example of a circumstance where lien subordination can turn into a payment subordination. Some other examples are disallowed post-petition interest. Should the first lien lenders be paid post-petition interest ahead of the second lien lenders, even when it's disallowed in a bankruptcy? Another circumstance that comes up that bears some similarity to lien subordination is when the intercreditor agreement or the underlying loan documents of the first lien creditor contain restrictions on the voluntary or mandatory prepayments that the second lien lenders are allowed to receive, or payment blockages. And sometimes we see that there may be an excess availability test before a second lien lender can receive certain payments. This is less common in market transactions, but in more privately negotiated deals, this comes up more and more. So we'll move on and talk about some of the familiar agreements that document these arrangements.
Yes. So, there are a variety of different agreements that are used to document these. An intercreditor agreement usually involves two separate lenders or creditor classes agreeing on the relative lien priority on a common pool of assets or collateral. That agreement sets forth the lender's rights and obligations regarding the loan parties and the collateral upon default or bankruptcy. The business law section of the ABA has set up a model intercreditor agreement, which is available on the website as shown in the slides. One thing to note, as Kathy was mentioning, is that intercreditor agreements and syndicated transactions can differ meaningfully from more closely negotiated transactions. The intercreditor agreement is more negotiated in club transactions because a lot of times in a capital markets transaction, the buyers buy the bonds or buy the debt based on term sheet when the intercreditor agreement has not only not been negotiated, but may not even exist yet. And a lot of the people that buy in primary deals do not necessarily hold through a restructuring and may not even plan to, and so they may not care as much about what some of those provisions are because they're going to sell. They plan to sell out if things go south. And one of the things that can make these situations very interesting is that particularly when second liens have traded down lower or to a very low level, you can see that there's a very different class of holders that will now be holding that instrument than had originally bought it, and maybe looking at it as a litigation option or potential for holding up the rest of the creditors or the restructuring, and how courts view the actions of those people can sometimes color how they interpret the intercreditor agreement.
Right, and in middle market or just privately negotiated transactions, and we're seeing so many more privately negotiated transactions even in the large cap world, given the regulatory scrutiny that banks are under today. A lot of the private debt lenders are able to provide financing for opportunities that, just doesn't make a perfect fit for regulated institutions to participate in. So in those circumstances, we're seeing those intercreditor agreements that may have, passed through without a lot of comments in prior deals, even in the syndicated market, come under a lot more scrutiny and negotiation by the second lien creditors. The next type of agreement that we wanted to bring up was the subordination agreement. And while there's not a standard form of subordination agreement, they tend to be a little bit simpler than the lien subordinations. And part of that is because secured creditors just have a lot more rights under applicable law than unsecured creditors. So there's more things to address in an intercreditor agreement that contains a lien subordination than in a straight subordination where it's unsecured debt involved. Oh, go ahead, Andrew.
Oh, I was going to say, and also I think another factor is that in a lot of intercreditor agreements, the second liens do have some rights, whereas it's very simple. Whereas some subordination agreements, it can be very simple to say that you have no rights whatsoever. Documents start getting longer once you start having to put in exceptions and if this and then that type stuff.
Yeah, that's absolutely true. So a subordination agreement is an agreement that the senior and subordinated lenders negotiate and enter into primarily to address the payment subordination terms. And as Andrew mentioned, the remedies terms are typically much shorter because they're just an outright prohibition on that unsecured creditor from exercising remedies. The most complex part is the negotiation of under what circumstances and in what amounts are they allowed to receive cash payments. So moving on, the third type of agreement. Now this comes up in unitranche transactions, and this is the agreement among lenders. They're all agreement among lenders, obviously, but this one is commonly referred to as the agreement among lenders. This is an agreement that's used in a circumstance where there's one credit facility, but there are different groups of lenders within that credit facility that are going to have different rights and priorities as to payment, as to the exercise of remedies, as to voting. The list can go on and on. This is a pretty bespoke arrangement. Some of the things that this agreement accomplishes, and it may not address all of these points, it may address all of these and more, but some of the hot topics are separating the debt into pools of first out and last out obligations, providing for waterfalls that allocate different priorities to payments after the occurrence of certain triggering events. They provide typically for complicated voting provisions or creating mandated deadlocks. They adjust pricing among the first out and last out pools. They set forth the conditions under which a majority of a first out tranche and a majority of a last out tranche can direct the exercise of remedies. These are intended to override the voting provisions that are in the credit agreement, where it might just be that majority rules. And they also set forth certain of the lender's rights and obligations upon the occurrence of defaults or insolvency events. There's not a model form for this arrangement. As I mentioned, this tends to be a fairly bespoke structure. And in circumstances where the lenders involved have precedent together, these transactions can be put together pretty efficiently. However, getting that first set of paper negotiated can take a lot of time. This is very complex. There are unique bankruptcy considerations to take into account that are different from the considerations where you have separate claims and separate liens. And those circumstances make these arrangements more palatable for some lenders than others. There are some lenders that just are not interested in participating in this structure with the risk profile involved.
Well, Kathy, could you say in what circumstances do people go to the trouble of negotiating that first form of unitranche agreement?
You know, a lot of lenders, particularly the private debt funds, have been focused on these, and what you generally see is you see regulated, customary first out lender consisting of a bank who can provide things like revolving loans and letters of credit and is looking for a lower return or has a minimum return that's lower, partnering up with some private debt lenders that need a higher return. And they partner up and they deliver to the ultimate borrower a blended interest rate and a one-stop shop approach. So it shows transactional efficiency, or it seems to appear that it can provide that. And in circumstances where they've done these deals before together, that is certainly the case. It's just one set of loan documents. It's a lot easier for a borrower to navigate rather than trying to maintain compliance with two separate sets of credit agreements and the like. And it can be less expensive for similar reasons. And so this is appealing for, especially if you're doing an acquisition financing, from a borrower's perspective, to just show one set of commitment papers. There's just, on its face, it appears that less can fall through the cracks. So you have more certainty of execution. Now, my caveat to that is, that's the case where you have folks who have already been through the process and are comfortable with the issues involved in this type of a circumstance. So there's a lot of lenders out there that have done this together for years. I've been working on these since the early 2000s when I started practicing. But today there's a lot more players in the market, and that can make things a little bit more complex when you have folks who are newer to the structure attempting to kick it off.
Thank you. And then on the next slide, we have an intercreditor comparison chart. I'm just going to go through this very quickly, just in the interest of time. As you can see, with the first and second lien and the split collateral, a lot of the terms are more similar compared to the subordination agreement or the bifurcated unitranche.
Yeah, that's right. And throughout the materials, we've included a couple of comparison charts for some of the primary issues, just to give you a view of them sort of side by side. Feel free to read through those on your own. We're probably not going to go through them in great detail, but we thought this would be a useful resource for folks to have at hand.
All right, so I think that wraps up our kind of introduction to intercreditor arrangements. So the next section of the presentation is going to be on key points of negotiation, and Catherine and Sarah will be talking with you about that.
Great, thank you. So we're going to kick off with the scope of priority obligations. What I mean by this is we've got two separate groups of creditors, or at least two separate lenders with different obligations. And whether you're talking about a lien priority arrangement or a debt priority arrangement, typically the creditor in the junior position is going to want to limit the amount of debt that can be ahead of it. And before you can start with that, you need to first describe what is the scope of obligations that's intended to be picked up by these intercreditor arrangements. So it's critical for both parties to have predictability about this. So it's defining the scope of obligations entitled to either lien priority or payment priority. So common categories are principal, interest, fees, expenses, indemnities, reimbursement for letters of credit. I think that there is typically an expectation of a first priority creditor, whether it's in a lien subordination arrangement or a payment subordination arrangement, to be entitled to include fees and interest and expenses and other amounts that accrue after the commencement of a bankruptcy proceeding, regardless of whether allowed. And then bank products and hedging. In a lot of deals involving banks, these are key revenue producers for them, and they try to set it up so that these are secured. So these are something that also need to go into the calculation. Moving on to the actual debt caps themselves. So the junior creditor or the junior lien creditor wants to know, okay, so now we've described the categories of debt that can be ahead of me, but frequently they want to cap the principal amount of the debt that will be senior. And that it is customary to only cap the actual principal amount of the indebtedness, but not the interest that accrues on that permitted senior debt. The one area where I see a fair amount of negotiation, at least in the privately negotiated deals, is around caps on bank products or hedging exposure, because otherwise that's just a complete unknown for the junior creditor. The other area is whether payment.
Well,
sorry,
Kathy, if I could jump in, it's also not only just that it's a complete unknown for the junior creditor, but it's something that might be manipulated in the future. If they agree to one thing, the debtor, the senior lenders could cause the issuer to take more or less hedging risk in a way that disadvantages the junior creditors.
Yeah, that's absolutely right. So this is the kind of thing where in market transactions, I mean, tell me if you see something different, but I don't generally see a cap unless you are in the middle market and you have a second lien lender that is really considering this debt as something they're going to hold. I don't see a cap on the bank products and hedging in most of the larger market transactions.
Yeah, I mean, I don't see that many limits on it, because often that's something that's in the credit agreement to make sure they're not going to do anything speculative, and
Right.
it's something that that the bank lenders would want to limit as well. But I think it also brings up one of the most general points, I think, for the general lawyers out there that I always thought was one of the most important things that I thought about when I was a lawyer, which is, whenever you're dealing not only with a particular agreement but with a particular provision of agreement, you have to think about when ambiguity helps your client and when it hurts your client. Because, for instance, in the context of a second lien, ambiguity about the priority of the priority obligations, or about what collateral is covered, can be helpful to your client, particularly if you end up buying in as a second lien in a secondary market, because they may be able to get, maybe we'll give them a litigation argument against the first liens if it were to go into default, to say that, some of the stuff that you thought was covered by the intercreditor agreement actually isn't. Or alternatively, if you're a second lien guy and there's some common collateral, or if there's some unencumbered collateral that you expect to grow significantly in the future in value, you might want to be very explicit about how that cannot be part of the collateral pool, because then that value would accrue to you, or would not be subject to the first lien security interest. And I think that's just one of the most important things to apply to negotiations generally.
Right. I totally agree. Paying attention to when ambiguity is favorable versus when it could, come back and bite you, I think is critical. And probably a lot of the transactions you look at, Andrew, the second lien creditors were not actively engaged in the negotiations. They may have bought it on the secondary market. So
right.
Looking closely at what they're buying into is pretty important.
Yeah, and I mean, that's one thing you see, as I mentioned earlier, that a lot of the people that buy in the private market have so much money to put to work that because of the timing, because how much money they have to put to work, they often don't see all the documents before they even buy it. Whereas people in the secondary market are often more careful in how they end up, in what they end up buying and what the rights are. And it's interesting to see how these documents end up working with each other with the underlying indentures. As the company goes on, after the transaction, they do other deals. For instance, in Hexion, when Hexion acquired Borden, the Borden bonds that they kept in place had a negative pledge over their U.S. principal properties. And now, if Hexion were to grant a lien on that, not only would they have to give a rateable lien to the otherwise unsecured Borden bonds, but the second lien intercreditor agreement would provide that the second liens would get a junior lien on that collateral, even though they wouldn't otherwise have a right to it. And then it's even funnier because it might be that the first lien was only granted to some of the first lien creditors, and you can get off into this totally different direction than what people were thinking about at the time that they drafted all these documents. And that's one of the reasons why intercreditor agreements, can be so interesting from a second lien perspective and so terrifying from a first lien perspective.
Yeah, absolutely, especially in light of today's market in the larger cap world, where there's a tremendous amount of flexibility for additional debt incurrence after the initial closing, and it can be tranched and retranched. It can be spun out into separate refinancing facilities, so you can end up with a series of pari passu credit facilities with a series of junior lien, all combined within one capital structure. And yeah, there's the risk of inconsistency between them and competing, covenants under the different ones that really can result in strange outcomes.
Yeah, and some and on top of that, sometimes there'll be an original first and second lien, and the definitions will pick up those particular those particular debt documents, but they've been refinanced, and since then a 1.5 lien's been put in, which wasn't explicitly contemplated by the intercreditor agreement, and none of these things were exactly none of the things were exactly fitting together perfectly, and you have to try to figure out what a judge or what the parties are going to think based on the language of the agreement and what people meant.
Yeah, exactly. It can get very complex, but so we'll go back to basics just a bit on the debt cap formulations and spend a little bit of time in the chart that we attached on slide 16. So just thinking about some of the different intercreditor arrangements: first lien, second lien, split collateral, subordinated debt, unitranche. Just a few things to throw out there. So how, going straight back to basics, like how is the debt cap constructed? Sometimes it's as simple as just a straight dollar cap that reduces over time as there are permanent repayments of the priority debt. In a circumstance where you're dealing with a piece of credit that is, underwritten as an ABL, so maybe you have lenders that are lending on a borrowing base, focusing on the current assets of the business, maybe AR and inventory, and then you have term lenders that are separately focusing on the enterprise value. So they're in both a first lien, second lien situation, or a split collateral situation. You may have a debt cap construct that, in addition to being tied to a straight dollar amount, it could also be structured to be either the greater of or the lesser of that straight dollar amount and a borrowing base calculation. These things get negotiated, and it really does go to how is the underlying credit underwritten from both perspectives of each of the classes of creditors. And then, of course, the issue we talked about, the cap on bank products and hedging, may be part of the calculation. And then usually there is a cushion in most transactions, and that's going to vary depending on the deal. The other aspect to think about is many credit facilities today will include incremental facilities. These are uncommitted facilities that are allowed to be implemented. And a lot of times the debt caps are set up to allow for that implementation in accordance with the terms that are in effect at the time the intercreditor is entered into. But that gets really complex as documents change, as Andrew mentioned, when they're refinanced or replaced. It's something you need to look at closely. over time as the relationships evolve. With respect to subordinated debt, the cap is usually pretty simple in that it's a straight dollar cap with a cushion of some sort. In the bifurcated unitranche, it's usually set up so that there's a specified dollar amount that is entitled to be first lien debt. There may be some provision in there to increase it to the extent that there are incremental increases that are allowed to be first lien. But those are the basics on the debt cap formulation. Andrew, did you have anything to add to those?
I don't think I had a whole lot more. I think that there's often a big issue with misaligned, expectations. Just, as you said, when the underlying instruments change, when the lenders change, and also when the company itself changes.
Absolutely.
Or the market changes and what they could, because sometimes people do debt deals expecting to take them out at a certain time, and then suddenly either the business or the market doesn't cooperate with that.
Exactly.
Yeah, Kathy, one other point is on the 10%, very often when I'm negotiating these agreements, I'll get pushback and people will say 10% is market. That's not really true when you're talking about the dip cushion. The dip cushion is enough money to fund the company out of the bankruptcy case. And so 10% of a large loan may well be more than enough money to do that, but 10% of a smaller loan balance may be inadequate altogether. So it's really important to think about what is the nature of the company and what is the level of expense that it would take to exit that company as a lender.
Yeah, I absolutely agree, and I should have mentioned that a lot of times there can be a separate dip cap, to protect the subordinated lender or the second lien lender from having that incremental cap used outside of a bankruptcy. Sometimes we'll include a defined term, the dip cap, and I agree that while it may fall within 10 to 20% in a lot of deals, that may not be sufficient depending on the cash flow needs of the business. So you really do need to focus on how much money is it going to take to get us through a certain period of time. All right, so we'll move on to the remedies standstill. So the senior lenders expect the priority rights to exercise remedies against the common collateral or obligors ahead of the junior lenders. And the language in the contracts that implement this are referred to as the remedies standstill. The remedies standstill prevents the junior creditor from taking enforcement action against the common collateral in a lien subordination, or if we're dealing with a debt subordination, against the common obligors for a specified period of time, and sometimes that is indefinite depending on the arrangements involved and the parties involved. It's designed to give the senior lender time to work through a situation and whether a restructuring can be achieved, and to really fully evaluate what the best course of action is with respect to the exercise of remedies. The standstill in a lien subordination is primarily directed at restricting the exercise of secured creditor remedies as opposed to unsecured creditor remedies. And the standstill in a payment subordination primarily restricts the exercise of unsecured creditor remedies because many payment subordination transactions don't involve a lien. If they do involve a lien, there's going to be a standstill relative to secured creditor remedies as well. The key points of negotiation in this arena tend to be around the scope of the prohibited action, what triggers the start of a standstill. So if it's not indefinite, what event caused that standstill to start to run? So if it's a 180-day standstill, what starts the 180 days? And then what's the duration of the standstill? I think that one of the areas that is interesting is dealing with the unsecured creditor rights, but we'll get to those in a later section. Andrew, what are your perspectives? I know one of the areas I see negotiated are the provisions around whether or not the junior creditor can commence an insolvency, an involuntary, or join someone else in commencing it.
Yeah, I mean, I think that's a very interesting issue. I mean, you saw that in Caesars where some second liens tried to file an involuntary petition, and it's also very interesting because if you file a voluntary petition and it gets rejected, you could be on the hook for damages. So but once you file an involuntary petition, usually the company ends up having to file anyway because of the drama that it causes with their supply chain and with the media. And so I think that I can see a lot of first lien lenders trying to prevent that second lien guys from filing an involuntary. Because in most circumstances, we talk about the remedy standstill, and it's kind of like the length of it almost doesn't matter in some ways, because in most of my experience, usually that just means whatever day, whether the standstill period is 90 days, 120, 180, it typically means that unless there's a resolution, the company's just going to file Chapter 11 before that standstill period is over, and they often don't have to do anything until the very end of that standstill period.
Yeah, I have a similar experience. What that period does tend to buy is if the company is working well with the senior lenders, it lets them approach the insolvency filing in a more orderly fashion, and to get things lined up like the DIP, and next steps maybe arrange a bidder, to contemplate a sale in a quick process. So having that standstill, it can even be beneficial to the company as well to have that in place if they've got, senior creditors that they're working with.
Oh, I totally agree with that. My point was more that it's not like a 120-day standstill period is more favorable for the second liens than 180.
Right.
Because that period's never going to end. There's going to be a bankruptcy filing before that period ends. It is helpful to the first liens to have a longer period because it allows them to work stuff out and thereby help preserve collateral value. But it's just I don't see a lot of second liens being we really need to push down this date, the length of this standstill period, because whatever that period, it's just going to cause them to take the same action they were going to do, 60 days earlier.
Yeah, I think the only thing that it does is it holds the senior creditors, accountable to them, pressing things forward to make sure that
Agreed.
value that might be out there doesn't go away. Sometimes when you let a distressed business just sort of hang around, you can lose a lot of enterprise value. So I have some second lien clients that really are focused on getting that as short as possible so that they can get a seat at the table sooner, even though it never may turn out that way. It just creates a perception and moves things a little quicker from our experience.
No, that's a really good point. I mean, having it shorter from that perspective is more valuable in terms of forcing the first lien lenders to do something, because there are definitely times where there are first lien lenders who feel like they're covered, who are just so asleep at the switch, so to speak.
Yeah. Right.
I mean, there was one time when I was a lawyer, and it was the thing that made most clear to me how much people just go away for the summer. We had a lender group, and we're we're the lawyers, and we got reports with their advisor, this company's in trouble, this company's going to file, happened to be an airline, and then our lender group was let's just extend it, whatever. And the company was it's like people come back from Labor Day, and it's literally they've suddenly read all the things that have been sitting on their desk all summer. This company was in Chapter 11 by September 15th, and because our lender group came back and was oh my God, what's been going on? Why didn't you tell us? It's we did tell you repeatedly for months.
Yeah, no, that's absolutely right. And if you have an active second lien creditor group, and we've got a bunch of clients like that, they're going to be at the table and wanting to be a part in the process, and frankly providing a lot of really valuable input on the best way out, because they're looking for the best recovery since they're at the bottom of the stack.
Yeah, in my example, I don't think we had any second liens, certainly not the top, and the government was part of the lender group, and so
oh goodness,
it was so there wasn't a lot of outside pressure.
Right. All right. Well, I don't want to take too much more time on this, but there is the chart on slide 18. I recommend you take a look through it. There's some good details in there. I want to touch on next the permitted actions, because even when you have these standstill arrangements, at least in a lien priority arrangement, there are specific actions that the junior lenders retain the ability to take, and those are things like preserving and perfecting their liens, accelerating their debt, because once again, this is not payment subordination, it's lien subordination. Filing proofs of claim in a bankruptcy, voting on a plan of reorganization. But the one area that is the most tricky is they fight to retain their rights as unsecured creditors. This is the area that can cause all sorts of problems. You can have a 50-page intercreditor agreement and undo a lot of the agreements that you come to with a provision saying, notwithstanding anything else in this intercreditor agreement, the junior creditors retain their rights as unsecured creditors. Andrew, would you be, or Sarah, anybody interested in commenting on that?
I mean, I agree. Those are the most dangerous rights, and you really have to be careful in how some of these, in everything in intercreditor agreements with how they are worded. Like there was one case that I recently encountered where the first lien's entitlement to hold back the second lien's inability to act was limited until the discharge of the first lien debt. In some circumstances, but not by the payment in full of the first lien debt. And this was a company in Chapter 11. So the Chapter 11 plan's going to discharge all of the first lien debt. But by saying it was tied to the discharge rather than payment in full, they at least left an opening for the second liens to do things that might cause the first liens not to get paid in full in cash.
Yeah, I think courts are pretty harsh around this. When you just simply put the override in, courts generally view that as a conflicting provision and find the agreement to be ambiguous and therefore decline to enforce it. So what I do when I do agree to that kind of provision, I always go back and add a lead in that says, except as set forth in, and then I specifically list every single bankruptcy section where we've granted rights in favor of the first lien lender, and then put the override in there so that you're carving out from the carve out the rights that you want to protect on behalf of your client.
Right. Otherwise, it just gets too circular and too ambiguous to have any expectations around what will be enforced. Okay. Well, let's move on to release of liens. So in order to fully realize on their secured position, and this obviously only comes up in a lien subordination, not in a debt subordination where it's not secured. But in order to realize on their collateral on account of their senior obligations, the senior lien holder will require the ability to drag along the junior lien holders on a release of liens on collateral that's being sold. Absent this, the junior lien creditor can impede the ability of the senior lien holder to realize on the priority asset. The scope of the ability of a senior lien holder to cause the automatic release of a junior lien holder's lien on collateral does vary, and it's subject to significant negotiation in privately negotiated deals. Some agreements that you'll see out there will provide that the junior creditor will automatically release their liens when the liens of the senior creditor are released, but this is something I more often see in what people refer to as a silent second lien arrangement, where the second lien lenders get a lien, but really they don't get the ability to interfere in anything the first lien lender is doing, and you see that in a lot of large market transactions. When you're dealing with lenders in a privately negotiated market, which can be in the large cap world, but it just depends on the makeup of the lenders taking on the second lien debt, but certainly in the middle market, you see these positions negotiated to provide greater protection to the junior lien holder's interest in the collateral, so they can't get dragged along unless the certain conditions are satisfied. And some of those items will be limiting the release of liens to assets sold in the exercise of enforcement rights, or limiting the release to assets sold by the borrower, but only if the sale is already permitted by not only the first lien loan agreement, but also the second lien. And sometimes that's further caveated only if there's not an existing event of default under the second lien at that time. Otherwise, they get to come back to the table. A big point is requiring the proceeds of those dispositions to be applied to permanently reduce the first lien obligation. So there's some deleveraging occurring to protect the second lien. Another parameter I see negotiated is requiring the terms of the disposition to be commercially reasonable and requiring the consent of a junior creditor if the sale is to an insider. So no automatic release if the sponsor is buying the assets. I mean, the whole point is to make sure that fair value is being received for the sale of these assets. And the last point is making sure that the junior creditor is getting notice of these dispositions. Certainly if it's an Article 9 sale, they should be getting notice if they're a lien holder, but sometimes these sales are conducted outside of an enforcement proceeding, and the junior creditor wants to have notice. They want to be able to come in and credit bid, participate in the sale, look at the terms, make sure that adequate value is being given on account of the disposition of the assets.
And you saw a lot. This type of provision was relevant a lot recently in Caesars and in education management, where senior lenders releasing their guarantee provided through the intercreditor agreement to cause junior creditors to give up a guarantee as well.
Yeah, that's right. You'll see that the drag along is not just as to liens, it's also as to obligors. So if they're selling the stock of a business, that the underlying entity that's being sold, that the liens on it get released as well. It gets released from the obligations. Those are you got to think these things through and think what is your exit and how do you preserve, depending on which side you're on, first lien, second lien. How do you preserve and protect the interests in light of the potential exit scenarios that could be pursued. So we have another chart there on slide 21 you can take a look at. I think the thing I would note is that in a unitranche situation, the agreement among lenders will need to have some language about release of liens, because it may be that it's a sale of all or substantially all of the assets in connection with an exercise of remedies. Sometimes I'll see that the voting provisions and the exercise of remedies provisions allow for the exercise of remedies. They may be silent about the release of liens. It's something that you need to focus on just to make sure that all the expectations are met to really complete the full process. And if there's nothing else on that one, we can move on to Sarah discussing use of cash collateral and DIP financing.
Great. So I'm going to talk for just a few minutes about some of the intercreditor provisions that are particularly applicable in bankruptcy. And the first one is the right to unimpeded agreement on the use of cash collateral or the provision of DIP financing. So this is really the first lien lender negotiating for its ability to make sure that the borrower has enough money to get through the bankruptcy case. The first thing is that you'll almost always find this provision in one section or one paragraph of the intercreditor agreement, going back to what we talked about earlier and the fact that courts really do look for provisions in intercreditor agreements to be unambiguous as a condition to enforcing them. One of the things that you want to make sure is that where you're talking about cash collateral, you're really using cash collateral concepts and you're not just merging the DIP concepts with the cash collateral concepts. When you think about the use of cash collateral, generally what you're looking for is if the first lien lender consents to the use of cash collateral, then the second lien lender ought not to be able to say anything about that. The other term that comes up is you want to make sure that as a first lien lender, you have the ability to agree to carve-outs that are necessary in order to get the cash collateral arrangement in place and get it approved by the court, and that the second lien lender doesn't get a backdoor objection to the use of cash collateral through the agreement around carve-outs. So that's basically all you deal with cash collateral. The DIP financing provisions are much more elaborate. So you first look at when you're looking at the intercreditor agreement, what is the conduct that you are really dealing with? And that falls into two different buckets. One is objection to a proffered debt financing proposal. The second is the ability to propose a debt financing arrangement yourself. So let's talk first about objections, because sometimes when you look at intercreditor agreements, this is all that's covered, right? It really just deals with under what terms and circumstances can the second lien lender object to debt financing that's being put forth or supported by the first lien lenders. And typically it says you can't do that as long as certain terms are met. You don't go over the DIP cap. We talked about that earlier and what the DIP cap looks like. You can't object as long as the subordinate lender gets to retain their liens. You can't object as long as you're not reordering the priority of the pre-existing relationship. So for a first lien, second lien deal, that means first lien's always first, or second lien comes behind that. For a split collateral deal, what it would typically look like is with respect to your primary collateral, the collateral on which you have a first lien interest, you stay first, it doesn't matter. With respect to, whether that's term loan, if your priority is property, plant, and equipment, then you would stay first with respect to property, plant, and equipment. Generally, there needs to be an absence of any provision that dictates how the case is going to turn out. So anything that says that you have to follow a plan that says X, or you must liquidate by a certain date. And the kind of middle ground that you often see is milestones are okay. So you can't say you've got to file and confirm a plan where you sell all of your assets, but you can say you need to file a plan by a certain date. You need to get a disclosure statement approved by a certain date. You need to be out of bankruptcy by a certain date. Another term that I think probably is one that gets the most heat around negotiations is a requirement where second lien lenders insist that the commercial terms, which we generally think of as fees, interest rate, and amortization, that those have to be commercially reasonable. Second lien lenders view that as sort of just a baseline fairness test. First lien lenders view that as a backdoor for the second lien lenders to get in and raise objections with the court, right? So it gives them the opportunity to walk up to the podium and begin to talk. And the argument back is ultimately the court will make that determination as to whether something is commercially reasonable. And if they find that it is, you've got no basis to have objected. And if they find that it's not, then the DIP won't be approved in any event. So lots of negotiation around that point. Sometimes we have negotiations around whether the first lien lender can roll up their debt as part of a consented to debt financing. Another thing you want to make sure that you're getting exceptions or carve-outs for professional fees. And obviously, if you're representing second lien lenders, you're looking to make sure that those pre-consented to carve-outs are limited to reasonable professional fees and that they don't pick up other types of administrative expenses. The final condition that sometimes you see is the second lien lenders will want prior notice, so they want notice of the DIP terms before they actually are filed with the court. That's kind of again, it's a backdoor to knowing what they've got planned in terms of timing for the filing of a bankruptcy case, venue. Generally, though, those are not provisions that are very heavily negotiated, although you'll often see them in intercreditor agreements. So those are kind of the list of things that the second lien lenders are looking for. The other big thing that they're looking for is the right to raise any objection that could be raised by an unsecured creditor. And then, of course, you have to carve out those DIP financing and cash collateral rights that it belong only to secured creditors and that go to whether you're adequately protected. So that's the basics on, what you're looking for in your intercreditor negotiations around the right to object to the a DIP financing being put forth. The other thing, though, that you need to watch for, though, is and to think through is what is the ability of that second lien creditor to propose an alternative DIP financing, because the proposing of an alternative DIP financing is really just another way to object. It's another way of saying I don't like what they have on the table, and court or creditors committee, U.S. trustee, you ought to consider this other better alternative that we're putting forward as a means to defeat what the first lien lenders are putting forward. The terms in the intercreditor agreement around the ability of a second lien lender to propose a DIP itself really range from no, never, you can't do it, full stop, to no, you can't do it if the first lien lenders are making or supporting a DIP of their own, to no, you can't do it if it's a priming DIP, but you can otherwise do it, to the other end of the spectrum that just says, okay, I didn't cover it in the intercreditor agreement at all, in which case the subordinate lender is free or the second lien lender is free to come forward and put forward any DIP proposal that they want. So that's basically the rules of the game around cash collateral and DIP financing. In the unitranche deal, you really mirror what you have in the first lien, second lien deal. We talked about in the split collateral deal, it tends to be very even-handed. You'll almost see mirror provisions in favor of each one of the secured lender groups in a split collateral, although there are some deals where they favor the working capital lender being able to have greater rights to provide that DIP financing than the non-working capital lender. And then, of course, in a subordinated debt deal, you typically wouldn't see any provisions around cash collateral or DIP financing, as the subordinated debt holder doesn't have a lien that needs protecting. Okay, let's go then to the disposition of collateral in a bankruptcy case. And this is really, borrower, debtor wants to sell collateral in which the lenders have a lien. The first lien lender is good with it. They've agreed to the sale. They're going to release their liens. And then the question is, what rights does that junior lender have to come in and block the sale by refusing to release their lien? And what the intercreditor agreement will provide, because as you recall, under the bankruptcy code, you can't force a lender to release their lien except in certain narrow circumstances that include they're being paid everything in full or they're consenting, among others. So the question is, that means you need that intercreditor agreement, right? You need that proxy to release their lien, particularly in a situation where they may be getting, little or no value. So the question is, what does that negotiation look like? Generally, the intercreditor agreement will provide that the junior lender waives the right to object to the sale, provided that the liens attached to the proceeds of sale and they're held, or all of the proceeds are used to repay the senior lender claims in full. Now, this is one where, the practical world really comes into play.
Go to my house, take out the trash,
because we, as you know, if you've been involved in a sale, the proceeds of sale are never exclusively used to repay the liens that secure them. Instead, they have to be used to pay professional fees. There's always a wind-down budget that needs to be addressed. And so you want to make sure that you're carving out, on behalf of those first lien lenders, the ability to satisfy those administrative expenses that are attendant to that wind-down budget or the sale itself. Junior lenders often will say, okay, look, I'll waive my right to object to the sale itself, but I still want to be heard with respect to bid procedures. That is very important to them. Or they may also want the right to object to anything that an unsecured creditor would have the right to object to. And then again, we talked about the limitation on the use of proceeds. Another topic that gets negotiated in this context is also, when you're talking about sales, who has the right to credit bid and when. The first lien lender's right to credit bid is almost always unfettered. The second lien lender's right to credit bid is rarely waived, and instead what you'll see is a formulation that says the second lien lender can credit bid as long as they pay the first lien lender in full, in cash, from the proceeds of sale at closing. So that's generally how that works. Let's see, I'm going to skip over the voting arrangements for the unitranche deal because that is as we talked about before, it's a much more specialized arrangement because I want to talk just a couple of minutes about reorganization securities and what junior lenders get to keep in terms of reorganization securities. So I'm going on to slide,
I think it's slide 32.
There you go, slide 32. And so reorg securities, what you're really thinking about are debt or equity securities that are distributed under a plan of reorganization. And the intercreditor agreement usually goes to, who gets to keep what. And the kind of rules of the road are when you're talking about equity securities in a first lien, second lien deal, let me back up. In a first lien, second lien deal, the junior lender gets to keep anything they get that is not a proceed of their collateral, right? So you start with that general proposition. Then you get into, okay, well, what do you get to keep that is a distribution on account of your collateral? The kind of practical reality is you almost always get to keep your equity securities. You often get to keep your debt securities but have to turn over all payments under them. Sometimes junior lenders can negotiate to be able to keep interest payments. Occasionally they will be able to negotiate to keep principal payments. But those are kind of the things that you need to be thinking about is, if you're representing a junior lender, am I getting something in a first lien, second lien deal? Am I getting something on account of my collateral? If the answer is no, you get to keep it all. If it's on account of your collateral, then you need to start negotiating. You start with interest. You're most likely to be able to negotiate to keep interest. Sometimes you get to keep regularly scheduled amortization payments, rarely all debt payments. Sometimes you have to turn everything over. So with that, Kathy, let me flip it back to you, and you may want to go back and pick up the prior section.
I think we're running low on time, so I'd love to jump to enforceability considerations, but I just want to point out to folks we're skipping over an important section, which is the voting arrangements. And I think that paying attention to amendments, restrictions on amendments to underlying documents, this is an area that can get complex fast, especially in the larger deals with the more complex terms allowing additional debt to come in. Take a look through those slides. There's some good information in there. I think that'll help you issue spot as you think about the restrictions on amendments, either in the intercreditor agreement or in the underlying loan documents that govern the different tranches of debt. But at this stage, I'd love to turn it back over to Justin, and he's going to run us through some of the enforceability considerations relative to intercreditor agreements.
All right, thanks, Kathy. So we'll wrap this up with some enforceability considerations here and mainly looking at a few of the bankruptcy decisions that have come out over the last number of years dealing with a lot of the topics that Kathy, Andrew, and Sarah were just discussing. So you see a thread in the case law or a tension between maybe a freedom of contract and a fundamental rights in bankruptcy kind of concept. So it's pretty clear that subordination agreements, intercreditor agreements are enforceable in bankruptcy. Section 510 of the Bankruptcy Code expressly provides that subordination agreements are enforceable under, to the extent applicable non-bankruptcy law would make them enforceable. The concept of a subordination agreement isn't limited strictly to a subordination agreement. Intercreditor agreements, and you don't have to necessarily worry about the phraseology that you use. Courts will look to the substance of the document, and if they are truly intercreditor agreements, subordination agreements, you will be within kind of the scope of Section 510. There are a number of cases here, and this is a pretty good list, I think, of more of the oft-discussed and cited cases when you're looking through this, so use this maybe as a handy checklist or something to look at when you're working through these issues on enforceability. So I'll skip through these fairly quick as we're running out of time. State law governs the interpretation and enforceability of subordination agreements. Well, we all know that applicable non-bankruptcy law can include state law, but it can also include federal law. And in fact, the case cited just above, Bank of New England Corp., has a fairly good discussion about applying state law when under the Bankruptcy Act, prior to the enactment of the code, there was this concept of a rule of explicitness and whether a creditor could, a senior creditor could get paid its post-petition interest, notwithstanding it maybe not being able to get that under the bankruptcy code and have that paid in full before a junior creditor could get paid. In that case, in Bank of New England, the court went back and looked and said, you know, that may have been the case under the Act, under some sort of federal law, but now that I have Section 510 and it tells me to look to applicable non-bankruptcy law, you know, I think I have to go back and look at state law, and New York law, for instance, doesn't recognize this concept, and so I'm kind of going to ignore that for now. So the state law component is important, and there are a couple of cases there that you can look to for that proposition. The courts in these two cases here cited at the bottom also talk a bit about, you know, subordination agreements will be enforceable and the bankruptcy proceedings won't really affect it unless we start talking about the intercreditor agreements violating fundamental bankruptcy law principles. So on the next page, if we could, some limitations that we discussed in some of these prior slides. The first couple of cases here deal with voting rights between the creditors and limitations on a junior lender's ability to vote on a plan. So in 203 North LaSalle, that's a very frequently cited case dealing with voting rights, and the court in that case essentially took the position that a provision in an intercreditor agreement that purported to allow the senior lien holder to vote the claim of the junior lien holder was not going to be recognized in bankruptcy court as essentially not consistent with fundamental bankruptcy rights. The court also looked to some of the provisions of the code and the bankruptcy rules, 1126. The court said the holder of the claim is the party that's entitled to vote the claim, and Rule 318 the court interpreted to be essentially the same way. There's another case in here where a court reached the opposite conclusion looking at the same provision. So, you know, again, if it's a fundamental bankruptcy kind of concept, some of the courts are looking at it and saying, well, gosh, I'm not going to let you waive that in a contract. And then other courts will look at it and say, there's a right to contract here, and you can kind of waive away some of these rights if you want to do that. So there's case law going both ways on that. The next case, aerosol packaging, that court there did allow, and that's the other case that you can look at for the proposition of these voting rights can be waived or can be assigned over to a senior lender, and they'll be enforced in bankruptcy, at least according to the aerosol packaging decision. And then kind of the same concept in Ion Media, there the court said that the junior creditor would have the right to object to confirmation of the plan. Would not have the right to object to confirmation of the plan based on the intercreditor agreement and the court's review of the provisions of the intercreditor agreement. Next slide. So here we'll just touch on a couple of these. Ion Media also stood for the proposition that the junior creditor could contract away its right to argue that the senior lender's claim is unsecured. We have a case here about consent to use of cash collateral. Same kind of concept in the Tusa case. The court held that the junior lien holder had bargained away its right to object to the senior creditor's right to use cash collateral, or right to consent to use of the debtor's cash collateral. 363 sales, Boston Generating. That case, the court took the position that in a lot of these cases, they really scrutinized the language in the intercreditor agreement. The court looked at the intercreditor agreement and just came away with the conclusion that although the intercreditor agreement had a lot of the provisions that we've talked about during this presentation, it did not expressly say that the junior lien holder could not object to a 363 sale, notwithstanding that arguably, probably did. It wasn't expressed, and the court took the position that if it doesn't say it on its face, I'm not going to enforce it. Next slide. provisions prohibiting junior lenders from moving for the appointment of a trustee. In Erickson, the court prohibited junior creditor from moving for the appointment of a trustee. There, the court kind of looked at the standstill provision in that case and was of the view that the junior creditor's attempt to have a trustee appointed was really a de facto leverage kind of play to avoid getting a plan confirmed or at least delayed so they could continue to negotiate and potentially through this leverage tactic, extract a little bit more than they would otherwise be entitled to if the intercreditor agreement was enforced as the court was inclined to read it. Consent to dip financing, and Sarah just talked a lot about the dip financing concepts. MPM silicone is an important case if you want to look at it. There, the court really scrutinized the terms of the intercreditor agreement. Same thing with the future energy holdings cases. You look at those, the MPM Silicones case is also important with, I think, a topic that Kathy had discussed with retaining rights as a junior creditor. In that case, the court had allowed a junior creditor under the provision that allowed the junior creditor to exercise rights and remedies of an unsecured creditor to object to a plan or to support a debtor's plan and do some other things that otherwise it might not have been able to do if that provision wasn't negotiated into the agreement. The next slide here, which is going to be our last slide, is a bit of an exception to the idea that intercreditor arrangements are enforceable under Section 510. So that will come up in the context of a cram down situation. Under 1129A1, you have to comply with all of the provisions of the code in order to confirm your plan. But if you look in a cram down situation under 1129B1, the code says it starts out with the provision notwithstanding Section 510A. And so the TCI2 holdings case looked at that language and said, I think I cannot enforce this provision of the intercreditor agreement, or at least, not confirm a plan over the objection based on some provisions of the intercreditor agreement, because Section 1129B1 expressly says, notwithstanding Section 510A, if all of the other provisions of 1129B are satisfied, I have to confirm the plan. And so that objection was overruled. Conversely, the Consul Restaurant Corp case, a bit earlier in time, they very briefly, in about a paragraph, looked at that same argument and essentially just ignored it, saying that even if Section 510 is written out of 1129B1, it's generally understood that these sorts of rights are enforceable under the discrimination, fair, and equitable concepts of the statute, and so didn't really pay much attention to that argument. So at the end of the day, you need to be careful when you're drafting your agreements and really have them say what you mean in order to have a good shot at having some of these things enforced. Depending on the district that you're in, you may find yourself in front of a judge who simply just does not take the view that some fundamental bankruptcy rights can be waived or otherwise abrogated in these intercreditor arrangements, and in some other courts, you may find some, a little bit less hostility to the contract arrangements that parties have reached amongst themselves, especially when it comes to some of these fundamental bankruptcy rights, and have a better shot of having those things approved. So I think the sum and substance of the enforceability, and Martha, I turn it back to you.
Great. Thank you to all of our speakers for joining us today and for your valuable insights. For those of you requiring CLE credit for this program, please allow our coordinator 10 days to send you an email with instructions on how to obtain those. A recording of this webinar will be available in our e-learning center at cle.abi.org on Monday afternoon. Registration for our next February webinar is open. This webinar will cover the bankruptcy appeals process and will include both bankruptcy and circuit court judges as speakers. You can find more information and the registration on our calendar of events at abi.org. Thank you and have a great day.